Hello everyone, and welcome to the October 2024 episode of My PIP Monthly. As always, my name is Amber Rouse Holloway and I'm a partner here at our Troy office. Now, our October 2024 topics will include, of course, a case law update. Today we'll be discussing actually a third-party case that is very much important to PIP benefits, the case of Joseph Canty v. Michael Chester Mason, and then moving on to trending topics in PIP litigation. It's kind of a piggyback off of no-fault reform, but we'll be specifically discussing the no-fault fee schedule and any updates, say, in the last 6 months or so. Now again, this Joseph Canty v. Michael Chester Mason is actually a third-party case, but it is a situation in where the plaintiff here excluded themselves from PIP benefits due to a Medicare policy and then sought payment of those medical bills. Instead of seeking them from their insurer, they sought payment of those medical benefits through their third-party case. Now, as we all know, the No Fault Act was reformed in 2019 to allow insurers to cap available PIP benefits or even exclude available PIP benefits to insureds with qualified health care plans like Medicare, and situations where some private insurance companies through your employer may also be qualified health care plans. Now, post-reform, MCL 500-3135 3C allows injured parties to bring third-party claims against tortfeasors for allowable expenses in excess of the claimant's policy limits, unless the claimant opted out of PIP benefits entirely, in which case allowable expenses are without limit. Now, here the Court of Appeals explained that the phrase "without limit" must be understood in context. It declined plaintiff's invitation to ignore all imaginable legal restrictions and instead holding that third-party claims are subject to the post-reform fee schedule, MCL 500-3157, and the common law duty to mitigate damages. So here again, we have cases, what we've seen a rise in cases where these medical expenses are being claimed in the third-party case, and then we have plaintiffs' counsels who are saying that the fee schedule doesn't apply because this isn't a PIP case. Of course, we've had situations where we've fought back in this, for example, with a motion in limine to indicate that the fee schedule does apply to the medical benefits, but I've had situations where that motion in limine was actually denied, wrongfully so in my opinion, and actually not in my opinion anymore due to the Joseph Canty case. Now, Canty sheds new light on this particularly murky area of law, its treatment of third-party claims. Now, most importantly, Canty answers what it means when certain claimants may seek allowable expenses under 3135 without limit, a phrase which, interpreted as expansively as possible, would have a catastrophic effect on tortfeasors and their insurers, and actually not the effect that the legislator was clearly intending when it enacted no-fault reform. Now, I did want to give some background to Canty. Here, obviously, it's a third-party tort claim. It arose out of a February 2021 accident in which defendant Mason negligently rear-ended plaintiff's vehicle. Now, prior to the accident, plaintiff had taken advantage of MCL 500-107, electing not to maintain coverage for PIP benefits. Obviously, a significant cost-cutting option that's available with qualified health insurance such as Medicare. Now, after the accident, plaintiff opted not to bill Medicare for his treatment, and instead he sued defendant under MCL 500-3135, which allows for injured persons to hold at-fault drivers liable for allowable expenses without limit. Now, ultimately, the court held that the phrase "without limit" cannot be taken out of context to mean there are no parameters at all. Essentially, the court held that the fee schedule does apply to these cases, and "without limit" does not necessarily mean that it's without purview of the fee schedule that was enacted to allow both claimants and insurers to have cost-cutting procedures. Now, ultimately, I do believe this case is a huge win for the good guys here. It doesn't get rid of, obviously, these PIP claims and the subject to the fee schedule, but it does cut them down significantly, which is what we were seeing when they were being claimed in PIP cases as well. Now, moving on to trending topics in PIP litigation. Again, I wanted to briefly talk about a no-fault fee schedule update and piggyback off of what was our case law update today. Now, as we all know, the fee schedule is enacted in MCL 500-3157, which indicates that a certain schedule does apply to treatment rendered after July 1st, 2021. As most of us know, the Michigan Department of Insurance and Financial Services, DIFS, better known as DIFS, does author bulletins, and I'll get to the letters in a moment, but these bulletins they're not binding authority, but they are very useful clarification on what carriers should be doing. The most recent on point DIFS bulletin that I wanted to discuss was issued on January 17, 2024, which discussed the July 31st, 2023 Michigan Supreme Court opinion and dairy. Now, the Michigan Supreme Court did affirm in part and vacate in part and reversed in part the Court of Appeals opinion in and dairy, but essentially said that Section 7 and Section 10 of MCL 500-3157 do not apply to the cost of treatment provided in persons injured in motor vehicle accidents occurring before June 11, 2019. Now, this is important to note that 7 and 10 are generally speaking, Section 7 and 10 are generally speaking regarding attendant care and claims that are subject to or not subject to Medicare or Medicaid assessment or application to the bills. Now, what I take this to mean is that if there is a Medicare code, then the bills and treatment rendered after no-fault reform and for anything other than attending care are subject to the fee schedule. I also take this to mean that an and area, as we all know, is not a provider suit. I believe provider suits, arguably, in contrast to and dairy, are not subject to the holding in and dairy and are more so subject to the holding in the spine specialist opinion by the Michigan Supreme Court, which is currently under appeal. So I guess we'll see in the very near future if I'm right or wrong with regard to this issue. Basically, it's important to note that the DIFS bulletin did clarify these issues and basically indicated that, of course, attending care, but in situations where bills are being claimed, that there is a Medicare code that corresponds with it, that the fee schedule does apply to those bills. And with respect to some of the letters that have allegedly gone out to insurers and carriers indicating that they should be applying the fee schedule to bills, to treatment rendered after no-fault reform, even if the accident occurred prior to no-fault reform. So again, you have a situation in which the motor vehicle accident occurred, for example, in 2017, but treatment is now being claimed for dates after no-fault reform, for example, 2022. Those 2022 treatment and bills should be subject to the no-fault fee schedule. And that's essentially what these DIFS letters are purportedly saying to insurers, that they need to apply the fee schedule to these bills, even if the accident is pre-reform, as long as the treatment is post-reform and there's a corresponding Medicare code. Again, pursuant to MCL 500-3157, the fee schedules pertain to treatment rendered after July 1st, 2024. It goes on to give another caveat for July 1st, 2022. But what's important here is that it says nothing about accidents or the actual accident or the date of the policy inception. What it's talking about is treatment specifically. So in my humble opinion, the date of the accident or the date of the contract/insurance policy are largely irrelevant when it comes to MCL 500-3157. And here in this slide, I just essentially say that everything I just said. I don't believe that issues such as these are controlled by ANDERI, especially in the instance of a provider case. The provider is asserting a cause of action under MCL 500-3112, which, in my opinion, the provider's rights could never vest until the provider actually has the treatment or until the treatment takes place. It can't vest when the policy takes place or when the accident occurs. It must vest at the time of treatment. And again, that's the case of Spine Specialists of Michigan v. Member Select. This is a really good one. Like I said, it is under appeal right now, and so we should be getting a ruling soon as to some direction. But until then, as the current law stands with Spine Specialists of Michigan, direct provider suits under MCL 500-3112, the cause of action does not accrue until services are performed. As such, ANDERI is not on point to these provider cases, but more so Spine Specialists of Michigan is, and therefore treatment, regardless of the date of the accident, regardless of the date of the policy inception, if that treatment is post-reform, then the fee schedule applies. And that is all I have for you guys today. As always, please feel free to contact me with any questions or concerns.